Rule 12, 1, my Lord, requires that there should be authority from the person authorizing, and under authorizing the deponent. My Lord, thank you.
There must be authority.
Authority.
Authorizing another person.
Another person.
To give evidence.
To represent. Now, when somebody says, I have been authorized by the first respondent, Order 1 rules, Rule 12, 1 and 2 require such authority to be in writing, which has not been done. Because of the limited timelines, permit me in the due course to submit authorities to that effect. My lords, they are being filed because we prepared them in the night. My prayer with respect to this is to pray that you find pleasure in striking out this particular affidavit. Going to the application, my lords, as I wait, my lords, with your permission, to have the copies submitted to court and to my colleagues, permit me to refer to the case of Binaisa Nakarema and 3 others versus Muchunguzi Myers. Binaisa Nakarema and 3 others versus Muchunguzi Myers. Miscellaneous application number 460 of 2013. My lords, it's a decision of the Honorable Justice Andrew Ashija of the High Court, and I invite you to find it persuasive to this Honorable Court, and it cites quite a number of other authorities. My lords, the grounds of this application why we seek to amend are that the applicant filed this petition number 1 on 1st February 2021 and served the respondents. 2, that the filing of pleadings is still ongoing. 3, that amendment to the petition is necessary to enable this Honorable Court effectively investigate and completely determine all questions involved in the petition. 4, that the respondents shall not be prejudiced by the amendment to the petition. The proposed amendments do not raise distinct cause of action in the place of the original. 6, that the original petition and proposed amended petition concern the same claim, and that finally it is in the interest of justice, equity and fairness that the applicant be granted leave. My lords, in his affidavit, he enumerates the chronology of events following the election, but of particular importance that following the election, after election, he was placed under house arrest, where he managed to get himself released from captivity after the intervention of the High Court, when he was left with only 5 days to prepare for and file this petition and gather evidence. In our submission, my lord, that's a disabling factor. For a person who is granted by law 15 days to be able to prepare and file an affidavit, in 5 days being left with all the post-detention trauma, my lord, we submit is ground for you to exercise your powers to grant the applicant leave to amend the petition, just to include a few of those aspects that are left out in the original petition. My lord, it is the impression, and we shall have your guidance, with your permission, that at the time of filing the amended petition, it is the impression of the petitioner that he would have been entitled to file an amendment without leave. But with the guidance from court following rejection of that petition, he quickly and without delay filed this petition. My lords, we have attached the order of the High Court that finally granted him some relief and release from house arrest. Our view, my lords, is that...
Councillor, the lordship do not have such an order.
Sorry, my lord.
We do not have such an order.
You do not?
I think what we saw in the application is the first page of the application for habeas corpus order or something.
Yes, my lord.
That's the only thing we have.
I will attach to the order, my lord. But it is attached to the supplementary affidavit, which I have referred to, of Mr. William C. Geoffrey, my lord.
The one which was filed when?
Which was filed on 8th February, which was yesterday.
Yesterday?
Yes, my lord.
The supplementary affidavit of you?
Supplementary affidavit in support of the notice of motion, my lord, filed on 8th February at 10:46 a.m. That is the one I undertook to surrender my copy earlier to the Honorable Lady Justice.
Yes. Right.
So, my lord, that is the order of the High Court, which eventually relaxed the restrictions on the applicant. My lord, the authorities we have reviewed of this Honorable Court on leave to amend. We have filed a bundle this morning on 9th February 2021, which invite your lordships to accept, and we have served copies onto opposite counsel. Because I was earlier guided and advised that I'm not going to read the authorities to this court, permit me just to make a few comments on the authorities we have submitted. The first is Mloza and Brothers Limited versus Elsha and Company Limited. It is civil appeal number 26 of 2010. My lord, in this honorable court emphasized principles for granting leave, and the court was of the opinion that amendments should be freely allowed, except where they tend to cause prejudice to the opposite party that cannot be redressed. In our submission, my lord, there is no my lord, prejudice occasioned or occasionable to the three respondents in this case. And the reason is that, one, the filing is still ongoing, and if you find pleasure in granting this application, as it has been in previous cases, the respondents will be given time to respond. My lord, the second principle that flows from these authorities is that the amendment is intended to enable this honorable court effectively adjudicate on all matters in controversy. And this is the position, in the Constitution, if you permit, my lord. My lord, If you permit,
Councillor, you have 5 minutes.
I'm grateful, my Lord, for the reminder and guidance. My Lord, if you look at Article 104 of our Constitution, in particular, clauses 3 and 5, the duty of this Honourable Court in election petitions of this nature is to conduct an inquiry, and then after due inquiry come to the decisions under 5A, B and C of our Constitution. And this is the same position under Section 58 of the Presidential Elections Act. Lord, how would you conduct an inquiry if some matters are left out, and especially when they are brought to your attention, your kind attention, in due course and in due time? Luckily, my lords, this is not without precedent in this Honourable Court. In addition to the case of Mlowoz I have cited, is the case of Mohan Musisi Chiwanuka versus Asha Chand and Supreme Court Civil Appeal number 21 of 2001. My lords, in another petition of which I would seek your indulgence, considering the volume that you find it pleasure to look at in our original petition, is Presidential Election Petition number 1 of the Right Honourable Amama Mbabazi versus Yoweri Kaguta Museveni and 2 others. And these 2 others, my lords, are the current other 2 respondents in this Honourable Court. In that particular petition, an application for amendment was filed went into more advanced stages than this particular one. In this case of ours, the application for amendment has been filed without undue delay. And also, finally, having been warned of the time, we are alive to the need for an expeditious hearing of this petition, which is provided for in the Constitution of our Republic. That said, and notwithstanding, it should be the undertaking of the parties, and on our part we do, that we shall expedite the filings once granted leave to file our amended petition, a draft of which we have already attached, and we do not intend to make any substantial amendment to that draft which we attached to the pleadings. The argument, my lords, that the election petition is time-bound, and therefore that this application should only have been filed within the same time limitation, does not have sound legal basis. Whereas it would be important, and if it were possible, to amend within that time, it is not law that amendment cannot be allowed after this filing timelines. Indeed, in Amama Mbabazi, this Supreme Court followed the same. We pray therefore that you will be pleased to grant leave, as the only way justice can be secured in an election petition. And indeed, my Lord, this is the only occasion, and it is the only opportunity for the quality of an election petition involving the presidency can be tested, and nowhere else, no other opportunity whatsoever.
I give you 5 more minutes.
Thank you very much, my Lord.
That's a bonus.
Well, thank you, my Lord, Justices, for the bonus, and I take it with gratitude. My Lord, the final thing I would like to say is that I invite you to receive the authorities, and the ones I have made reference to have now been placed before the Honorable Court. And that is the authority of Lena Nakalema Binaisha and Myers Mchunguzi, and a number of others, including Awori Media Uganda Limited, and another versus EcoBank Limited, my lords. It's authority number 5 in our bundle. It is miscellaneous application number 1105 of 2014. And the final authority is MS Fangmin versus Belex Tours and Travel Limited, Supreme Court Civil Appeal number 06 of 2013. My lords, what we are seeking for is an opportunity to present to you all the necessary material that is enough for you to inquire into this election and determine. The answer, which seems to be joint and common from the 3 respondents, not without prejudice to my earlier prayer to strike out the first, the so-called first respondent's affidavit in reply, seems to be that this applicant had some level of freedom in terms of chatting with lawyers on telephone, by telephone. The answer, the common answer from the respondents, seems to be that the applicant had ample time within the restrictions placed onto him at his house, where he could speak to lawyers by telephone. Having confirmed by judicial pronouncement that the siege itself was unlawful and illegal, it disturbs the person, that a person who has conducted an illegality can seek to rely on it in the Supreme Court of the land. It can only work in professions that are insensitive, and I submit ours is not that insensitive to liberties. That you confine somebody illegally and you say you had the liberty to instruct lawyers by telephone. Luckily, by rejoinder, the applicant has responded and answered that by saying that within those limitations his concentration was on his freedom, and therefore it could not be and should not be used as a basis to deny him leave after being denied 10 days. And by the affidavit, to date, his office of the National Unity Platform continues to be under siege by the same respondents, except the second respondent, with immense respect, that they deny him the freedom, then come to court and say, notwithstanding the unlawful activities meted out unto you, you should not be granted leave. I invite this Honorable Court to exercise your powers, my lords, within the laws cited, and to find a pleasure in granting this application. The so-called my lords.
I have not heard you discussing the 6th ground. What is the petition? What is the amended petition that not raise a distinct cause of action? I have not heard.
May I, my lord, with gratitude, make a short answer to that. Thank you very much. One, the authority of Mloza and Brothers, first of all, answers the question that even if the amendment or the amendment sought seeks to bring in a new cause of action, it would still be allowed along the considerations I have elaborated. But in our particular case, it is not raising anything substantively new. One, in the original petition, we are challenging the election for non-compliance with the law. The only things we are adding are aspects of non-compliance. Two, that there were illegalities committed. And the application and affidavits explain those matters that eventually came to the attention of the applicant after he had left siege. But they are not filing a new petition. Those are grounds, one, of illegality and non-compliance. In the hope, my Lord, and the faith that I have answered your question, I still invite you to grant this application.
Are you not asking to reduce further evidence?
No, my Lord, evidence is still ongoing. Evidence is still ongoing. We are still fighting, and by the precedents.
Can that be a ground for amendment?
No, my Lord, not that we have come across new evidence. The evidence will have to come in to support the petition as it will be standing on the record. The grounds.
Actually, you repeated that you still continue to file evidence. In other words, the process of filing evidence is still continuing.
True, my Lord.
I got it right?
Yes, my Lord, with the caution that the question is coming from the bench. Yes, my Lord. Because we have not even filed a rejoinder. We were just served with the answers just the other day. So we have not even filed a rejoinder, which is an essential pleading. And the process, therefore, filing pleading is still on.
Must you, after the evidence, even wait for the reply or the rejoinder or evidence?
No.
You filed your petition on the 1st
Yes, my Lord.
of February.
Yes, my Lord.
9 days later, I've not seen, unless you have brought to my attention.
My Lord,
I'm not seeing the affidavit.
my Lord, your attention is spot on.
Yes.
Yes, we have not. Because
I'm still waiting for all this process to end. And then we can...
No, my Lord, absolutely not, my Lord. We are collecting evidence.
Are they contingent on these applications?
Certainly they are not conditioned to the application, although it would have been much neater and smarter if it did, because including the grounds raised in the amendment, if you permit it, then we would have to adduce evidence to prove them. But yes, for the previous grounds, the process of collecting evidence across the country is ongoing within the restrictions available to us.
Okay, let me not pursue that line.
Thank you, my Lord, but I still thank you for your guidance.
No, before you say, I think we need to clear something over a question I raised. I asked you earlier whether the supplementary affidavit of Yasim Jofre is on record. This is a copy of the notice of motion. And the attachment of Yasim right here.
My Lord, thank you.
Just a second.
Yes.
With one page, I reviewed this file and sought inquiry from the registrar whether there was a problem with my file, and I was informed that was the case. Before coming forward, I inquired from my colleague whether the problem was with my file or all of us. All of us were unanimous that when we had one page of Yasima documents affidavit. Between the file being fixed and us arriving here in court, I see here on record the affidavit we are talking about. The same date and it's complete. I think this is the true one. These proceedings are being covered on national television and must be honest. Because we don't want to give the impression that the court has documents on file and we are not reading them. And this applies to all parties. So, my question to the registrar, when did these documents get out on my file? Because they were not on when I released the file from my file. And I don't know whether the same applies to my book. Because we're going to be here. When I come here, I'm speaking from the documents that were on my file when I released them from court. If they are counsel, you know very well, if there are any other documents you need to put on record, they just can't be smuggled on my file or any justice's file. you have formally requested. So I don't want this to go without being noted that documents have been placed on my file and that my and others did.
Well, my lords.
Okay? So we need to make a formal application.
My lord, before
documents to be tendered in because at the time we came here, they were not.
First, my lords, I want to thank you for the matter is raised, and it's a very serious matter to the extent that it touches professionalism on our part. The affidavit I have, and I sent to court.
Why do you want to thank us? You just oblige.
My lord, that's how I was brought up.
No, you oblige. Just oblige us. That is all you need.
My lord, thank you. By reason of obligation, I'm doing it. My lords, when we sent the document in issue, as referred to by her lordship, we sent a complete affidavit, which has all the 3 pages, and that has 12 paragraphs. It was received in court on 6th of February. I am not in a position to explain the process between then and now. It is therefore not correct, my lord, with humility, I must say, that...
Are you referring to the supplementary affidavit?
No, my lord. The original affidavit in support by Triam Sima.
That's how many?
How many does he have?
There are 2 affidavits, my lord. The first accompanied the application on the day of filing. And I think that's the one the Honorable Justice Nama Achisate is referring to. That is the first. The second, which is the supplementary, was filed on 8th. Now, with reference to the 2 affidavits, we sent complete documents, and that's how we have them. And those are the same that we served on to our colleagues. I am very surprised that there is something amiss. And my lord, in our practice, if that had been brought to my attention, there would be no bar in formal applying to rectify that.
So that's the first question.
Yes, my lord. There are 2 affidavits, both of which we filed complete documents. And on different dates, my lord.
And this supplementary affidavit, the second one was filed?
No, my lord, yesterday. Or you will refer to the one of Chaglan, my lord.
Yeah.
William Sima was yesterday 8th. And the time indicated is 10:46. With 7 paragraphs.
So the second one has
7. The first one had 12 paragraphs. If it's a question of arrangement of pages, my lords, then I will take responsibility and seek your indulgence to substitute it with mine, which is complete, in the event that there is no objection. But anything to do with smuggling, it's not my practice. Yes, my lord.
Now, can you go to the affidavit in support of the notice of motion?
That one, my lord, there are 2? Yes, my lord. Yes, my lord. It is complete, my lord, from my
The
end.
document says it was received on the 6th of February, as you said.
My lord, that one, yes, is 6th February.
The next A is payment slip.
My lord, annexure A to Triam Sima?
Yes, paragraph 6.
Yes, it talks of the payment slip. Although, my lord, on the application, I see the payment slip as annexure D.
No, I'm on the affidavit. Mine has no attachment. I refer to attachment.
I am actually in agreement with you, my lord, on that. A payment slip attached to, yes, my lord, I agree. That one is true. By way of...
Similarly,
that's a mishap, for which I apologize, my lord. But I find the payment slip attached as an extra D to the petition. I think it was a question of arrangement, which I invite.
It was received by phone on 6th February last week.
Yes, my lord.
Now, it was sold on 8th February.
I noticed the same anomaly, my lord. And I submit, yes, it was an anomaly.
No, it's not just an anomaly. Can we go back to...
Don't you think that is something that should be investigated?
Well, my lord, I'm not averse to an investigation into that, because all the filings have been guided by court and this one. And you will find that it's an anomaly in terms of dating. Otherwise, the filing was done on the dates and the face of the document. Because at every stage...
Did you find here this document? Document which, did you find here a non-existent document which you have went and prepared?
No, my lord. I find an existing document where the dating was an anomaly. As indeed you will find an extra D to the petition itself, I mean to the application itself, has a date which is... sorry?
What is an extra D?
An extra D, my lord, is the payment slip.
Okay. Now forget the pleading.
Yes, my lord.
Let's go to the affidavit in support of notice of motion by Toriamusi Joseph. It was received here on the 6th of February.
Yes.
If my memory serves me.
That's correct, ma'am.
That was Saturday.
That's where I said...
Then after we filed it here, you took it for swearing. Because
no, that's
it is sworn on the 8th of February, which is yesterday.
My lord, that is the anomaly I am referring to. And if you follow the chronology with your permission of the filings, that is why you would have a reply filed yesterday on 8th.
Councilor Bello.
Yes, my lord.
You are a senior member of the bar. You are not somebody who practiced law for 2 years.
I agree, my lord.
How do you rectify an error, if you call it an error, in affidavit?
My lord, there are two ways. If you notice it before coming to court, you swear another affidavit to clarify. In the event that that is not possible, as it appears now, is you get the person who swore the affidavit. If court is pleased to put him on the stand. That is the second. And those are the only two.
I put the commission of the oath.
My lord,
he is the one telling us.
it is the power.
He commissioned this person for this document on the 8th.
My lord, it is still the power of this honorable court to summon, including the commissioner. Yes, my lord. Yes, my lord.
You found a rejoinder.
Yes, my lord.
There were 3 affidavits in reply.
Yes, true, my lord.
Two.
True, my lord.
Why did you qualify one rejoinder? Why did you rejoin all the affidavits?
My lord,
Separate.
with your permission,
I don't need that permission.
thank you, I will answer right
I
away.
am asking you a question. Why did you grab your rejoinder?
My lord, there is a single rejoinder by the same person, and he answers the 3 affidavits in substance.
So that's why you're being asked why. Why you love them?
My lord, it is the style I know.
Okay.
However, I will continue to learn from the bench that I would need 3. My view was that it was neater as long as the affidavit answers the 3. And it is the petitioner's case and the applicant's case that he is able to answer the 3.
So I'm not comfortable with that style as well.
My lord, I undertake My Lord, I undertake in the future to cultivate that comfort. It's my undertaking.
But you know, it is made that correspond certainly. Because these are three different people.
Now, Professor Ogwena,
Yes, my Lord.
can I take you to the affidavit of the petition, the applicant,
Yes, my Lord.
in support of the notice of motion? What date was it on? Before the commissioner votes?
My Lord, by the same handwriting of the commissioner, the same anomaly continues to run.
So his affidavit, he saw it on the 8th of February.
No, my Lord, there is no possibility that it could have been shown then when he had already...
And then it was filed in this court on the 6th.
That's the point I'm making, my Lord, that the same anomaly by the said commissioner continues.
So what
My prayer, therefore,
What is the effect of
in the event... The effect,
what
my
is the
Lord,
effect of this defective affidavit
my Lord,
on your application?
my Lord, the effect is that it is not defective, but there is an irregularity which I concede to.
Why don't you say they were in different time zones?
No, my Lord. I wouldn't say that, my Lord, because that is not true.
Yes?
The reason I wouldn't say that, my Lord, is because it's
Council made that decision. So I hope you appreciate it's not a simple.
No.
Not the possibility. There is the possibility of what you're pursuing. That where, for some reason, the Commission of Post believed it was already 8th, then it was 6th, or early. No? It's a possibility. It is also a possibility that the Commission of Post did swear this affidavit yesterday, the 8th, and someone who came to file here played games with the registry and said that date. That's why we're really concerned.
My Lord, I appreciate the concern. It is legitimate and genuine. However, I'm persuading you to take the former possibility of a mistake on the in terms of dates. Why? Because these are applications which have been before you, placed before 8. Certainly it was a dating irregularity on the part of the commissioner. We accept it, but we think it is curable under 126(2)(e) of our Constitution. The applications have been on your desks, my lord, in your chambers. There is no way being substituted. In the unlikely and microscopic event that the latter proposition, as you are stating it, my lord, is another possibility.
There is a third possibility.
Yes, my lord.
In your haste, you came and filed documents supported by affidavits which were not commissioned. Then you retrieved them, ran to the commissioner for oath, but the commissioner, being a good Christian or good Muslim, stuck with the date of yesterday, when you have already filed it.
The third possibility is vitiated by two factors. The first and most important factor is the integrity of the court system, and my own undertaking as a professional that that's not true. But there is also the possibility, vitiated by the fact that it has not happened, and this court has had the documents, so that has not happened, as a matter of fact. Indeed, they were served earlier, so we could not have retrieved the documents from court and then retrieved it from opposite counsel.
Okay. Thank you so much.
Thank you.
Can we hear from the first respondent, counsel? Where is our team? Please sanitize the... Our team will do it, Mr. President. No, we will do it. You can, however, sanitize your hands. That's okay. You know that you have to have when you are sanitizing. Where is our team? Please have the phone of the surrounding area. Sanitize the desk, the table.
and all the Honorable Justices of the Supreme Court. I am Robert Yenke. I'm going to address the court on behalf of the first respondent in respect to the application. My Lord, Your Lordships, I will swiftly with the objection to the affidavit of Mr. Oscar Chihika. My Lord, the objection really is misconceived because Order 3, Rule 1 has nothing to do with the presentation of affidavit evidence. The presentation of affidavit evidence would be governed by Order 18. My learned friend has not made reference to Order 18 at all, and therefore I will not spend time on that. What I should point out to this Honorable Court is that Order 3, Rule 1 is about appearance in the court. In my understanding, it means the physical appearance of somebody on behalf of somebody else to attend proceedings. And therefore, if somebody turned up and said, I'm here to attend the proceedings on behalf of the first respondent, that objection might have some water. Mr. Chihika is actually not here. So the question of physical appearance does not apply at all. What Mr. Chihika did was simply swear an affidavit in evidence. He swore it in his capacity as the Director of Legal Affairs of the National Resistance Movement. I think the court can take judicial notice that the candidate, President Yoweri Museveni, was the candidate for the National Resistance Movement. So he's not, though he's not a corporation soul, he is not alone in this matter. He represents the National Resistance Movement. I should also point out that Mr. Chihika is an advocate. And there is no difference between what Mr. Chihika has done and what Mr. Triasima has done into affidavits. The ones he's been discussing, my Lord, which you call effective, and which, my Lord, I will leave to your Lordships, as you pointed out what issues they are. So on the basis of that, my Lord, the objection should be dismissed. And now I turn to the issues at hand. The first respondent objects to the amendments on a number of grounds. The first is that actually the law governing the determination of presidential election petitions does not provide for amendment. Does not provide for amendment. It is also our submission that in fact it does not allow amendment. Your Lordships will note and know, of course, that there are rules for the determination of the presidential election petition. Those rules provide for a fixed number of events. Those rules provide for a fixed number of events. And these are as follows. One, they provide for the filing of a petition. Two, they provide for the service of the petition. Filing within 15 days. Service within 2 days after filing. Then they provide the third event, answer within 3 days. They provide a fourth event, particulars, should you want them, apply for them. And then they provide for a final event. They provide for particulars as a possibility. That is the one application they provide for. If you don't have particulars, apply. And then finally, they provide for hearing. All in a very fixed time frame. Each of these steps has time. the time for hearing is already upon us. As of tomorrow, under the rules, we're supposed to be hearing the petition. With that time frame, it's our submission, they don't allow amendment. My Lord, I'll quickly answer the question of Mbabazi and Mbabazi's petition. They did allow. So somebody might say there is a precedent. It is my submission that the circumstances are completely different. After the Mbabazi case, this honorable court made recommendations. Among them, one for time. The recommendation was that time should be extended to allow the process to be carried out fairly. Now the amendment then came, and it is what we are dealing with right now. So the conditions in the Mbabazi petition were completely different. And the need to invoke substantial justice no longer obtains. The applicants have invoked the civil procedure rules. It is true, the civil procedure rules are introduced into presidential election petitions. But the introduction is limited. The introduction is limited. The introduction, if you look at Rule 15 of the presidential election petitions, is for the purpose of trial only. Trial. And my lords, I don't need to explain to you that filing and trial are completely different events. Before trial, you file, you plead, you close pleadings, then you try. So it is my submission that you cannot go and extend these rules beyond the extent to which they have been introduced. Alright. So, our submission therefore is that the power to amend in this short time frame does not exist, because that specific power to amend has not been incorporated into the presidential elections petition rules. The provisions of CPR cannot override the timetable set by the presidential elections petition rules. To finish this point, I'd just like to point out that the timetable of the civil procedure rules cannot fit. They cannot fit. If you are to apply them, you cannot apply a rule by changing its language. You must apply the rule as it is. Of course, with modifications, but the modifications must not completely change the process and turn it into an ordinary suit. So if you go to the rules, you'll find the period there talk about 15 days, 21 days, 7 days for the various acts. So it is our submission those rules don't apply. I'd like to move to the second issue. It is our submission that even if this court finds that it has the right to amend, it cannot allow any amendments that are made after the expiry of the time for filing the petition. The time for filing the petition is provided by Article 104. It's of Article 2. It is 15 days. So that passed, the 15 days. We are no longer at 15 days. We are now at at around 24, 25 days. We're way past. So the question is, can you still allow amendments? And the reason is, the effect of putting a time limit is to make a limitation. If you want to bring your petition, bring it within 15 days. Now, election petitions are not ordinary matters. This entire proceeding is an extraordinary proceeding. It's extraordinary for a reason. It's very important. It's very important in the life of the country. It's important in the calendar for the people to change government, to move on from one phase to another. So the reason why they chose the Supreme Court is because time is important. Time is very important. So they didn't want appeals, they didn't want issues. Let's go to the highest court in the land and let's resolve this.
Also, dear Chair, just one thing and then we'll take a break.
Yes.
Your learned friend, Nadu Councillor, argues, you heard him.
Yes.
He does not disagree with what you're saying, but he says this being a presidential election petition, all the matters that are in computers need to be addressed.
Yes.
So when we come back, can we start from there?
Yes, my lord. I can start from there.
When we come back in 15 minutes.
Yes, my lord.
Then we continue.
Most obliged.
So we've got to stand this matter over for 15 minutes.
Stopped was the day we found where to go. From now on, we are not going to leave anything on our plates, because we've learned to savor the moments that were always there, and they never tasted this